I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. Today we're going to reflect for a minute on the implications of the Fulton decision from the U.S. Supreme Court. That is the case, as you will recall, where the Supreme Court said that merely holding a debtor's property is not a violation of the automatic stay. In other words, if you're holding a debtor's property, you don't have to just give it back quickly, immediately, because the debtor filed a bankruptcy petition. That has raised a number of questions. For instance, what about a prejudgment attachment of a debtor's property? When you file bankruptcy, do you have to release the attachment on request by the debtor? Well, now in the last 2 months, we have two decisions, both I think very persuasive, saying that no, a creditor is not required to release a prejudgment attachment, just simply on notice that the debtor is in bankruptcy. Yesterday, in my column on the ABI website, I reported a decision, very well reasoned, by the Ninth Circuit Bankruptcy Appellate Panel, saying no, you're not required to release a judgment. That decision agreed with a decision from, I think it was October 6th, from a bankruptcy judge in Pennsylvania, saying much the same thing. However, both of those decisions had a little glimmer of hope for a debtor because, for instance, in the BAP decision from a few days ago, Bankruptcy Judge Ferris, who wrote that decision, noted that the creditor, after learning about the bankruptcy, immediately told the state court to stop the proceedings in the attachment action. Well, that little comment and a similar comment by the judge in the Pennsylvania case is suggesting to me that a creditor does, in fact, have a responsibility for notifying a state court to stop a proceeding that might end up in taking a debtor's property. For instance, let's say that in state court there is a motion sub judice requiring the debtor to deliver property to the creditor. Well, to me, the implication in both of those decisions is that upon notice of the bankruptcy, the creditor does have a responsibility for telling another court to stop. Am I right? Am I wrong? I don't know. But I think there's a good chance that if a creditor allows a state court proceeding to go ahead after bankruptcy, well, then there could be a stay violation and there could be sanctions. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something I hope that's interesting in the world of bankruptcy. Until then, be well, stay safe. See you next week. Good day.